There we go. I made a little bit of space there between us, Steve, because
All right, there we go. Making space. So
usually we figure
John,
this out about 40 minutes into the program, and we sort of get a little elbow room, you know?
there we go. Well, man, John, it seems like it's been forever. We took Thanksgiving Day off because you didn't want to do a live for all of our fans on Turkey Day. So I guess I can
Right.
appreciate that. But here we are coming to everybody live with Legal Ease with John Weiss and Stephen Palmieri. So, John, what's new in your world? We've got Regulation F that went live this month, which is the FDCPA regulation. What's on your mind? What's happening, brother?
Yeah, so that's a really interesting thing. And then other than that, we're just cranking here towards the close of the year. It's sometimes December is slow, but for us, we are just rocking and rolling with depositions and mediations and even some trials, and it'll slow down, the week of Christmas. And but happy to see you because I assume this will be our last show for this year. I think otherwise we'll be right around Christmas.
I don't know. Let's pull up the calendar. We've got the 23rd, Thursday the 23rd. I mean, the eve of Christmas Eve. I mean, dude, I'm down. We can't let our fans down.
But we'll
Maybe
see.
those of you guys watching us
See if
live,
anybody
leave a
wants.
comment below. Do you want to see us on December 23rd? Would that be way better than going to the mall and catching the Omicron? I think so. So comment below if you want
Is
us
it
to do that.
Omicron or Omnicron?
Oh, Ami, excuse me, it's the Greek alphabet. Omicron. Yes,
Omicron.
I
Okay.
put the Omicron. I failed Greek in high school, I guess. What can I say? So,
Well, what's
all
going
right. So
on with
let's
you,
let's
man?
jump into this thing, John. So what's hot on your end, man? You got any cases you're working on? Anything exciting for us to kind of dive in here for our fans and our listeners?
We're suing the bureaus, suing debt collectors, and the Regulation F is a very, very interesting thing. So that's where the FDCPA has been modified. It really hasn't changed anything with the FDCPA, but the Consumer Financial Protection Bureau has just made it very clear, for example, how collectors can email you, text you, how many times they can call.
Again, hold on. And I say I hate to be that guy, but I love being that guy that
You
always
are that
interrupts
guy.
you. I am that guy that always interrupts you. You literally see. This is the thing for our viewers. This is the thing about attorneys. So you literally just said the CF nothing changes with the FDCPA, but the CFPB makes it clear. So hold on a second. The FDCPA is like a 10-page statute. Regulation F is 600 and freaking 50 pages. How does a regulator need to write 650 pages to make a 10-page statute clear for me, John? I'm confused, man. Help me out, brother.
Yeah, you got to read the real thing, not all that long stuff. So, I will. I'll pull this up and let's see if I can share my screen here.
All right, you're gonna pull it up, but if you go to the CFPB's website and pull it up, I guess it has all the annotations and whatever comments, but it's literally like 650 pages, and it's like,
Yeah,
could we just stick with the 10-page law? What's wrong?
gonna get you to a better way to look at it. So we go to interactive regulations here.
Look
And
at that! Look at that! That is your tax dollars for work, at work right there. Interactive.
so here we go. Recently amended November 30th. And so you look at the current regulation. And so I do know what you're talking about. There's a PDF that's ridiculously long, but it's got a lot of extra stuff in it. This is the
Extra stuff. Is that also an official legal term, Your
that
Honor? That the
official
extra
legal.
600 and something pages, that's just extra stuff. Really, we want to focus on these two lines that are, whatever we want to focus on.
So here's the significance of this. It tells you what the rule is, and then gives you this official interpretation. And a lot of times it'll give you examples. And so, for example, they will say that normally a debt collector can call you 7 times in 7 days. Okay. But what if you have multiple debts? Or what if they speak with you? And so you go to this official interpretation, it gives you all sorts of examples. So it's actually pretty good. The government did it, and it's actually kind of makes sense, which is shocking in a lot of ways.
holy mackerel, John
Yeah.
Watson. That dude, they must be knocking on your door trying to disappear you because you never say nice things about the U.S. government. So I've got to wonder what's going on behind the scenes there.
Yeah, I may be
Good, huh? Wink,
disappearing
wink.
here.
So
But
All right, for those of you guys,
yeah,
joining in, we are comment below. We are talking, I guess, about anything and everything, but Regulation F right now, which is FDCPA reg. So, all right, so let's dive in. So, how does this change? How does it change how you practice FDCPA law? Does it affect anything at all, really?
It's really good for consumers. A lot of consumer groups were concerned and still are concerned about it. I'm just telling you, it's great for consumers because what it does is it makes clear in today's technology what the FDCPA means. So, give you one example. The FDCPA has always said if a debt collector communicates with you in an inconvenient way or time, and they know that, then that's a violation of the law. Well, what does that mean? And they say, well, if they call you before 8 a.m. or after 9 p.m. But now the CFPB has made it clear if you get a text message and you write back on that text message, hey, the only time that it's convenient for me to get an email is 1 to 3 p.m. on Monday, Wednesday, Friday. That's what the
hold on again. I hate to be that guy, but I am that guy.
You are that guy.
Let's go ahead and just back up for a minute here. So first of all, this is important. So they can text consumers now under the regulations, correct?
If they follow the rules, they can text.
Okay. Yeah, follow the rules. Right. Oh, I got you, John. Okay. They can also do social media posts and messengers. Is that right? Or just messengers?
Messages, yeah.
So they can't post up on your timeline and be like, you deadbeat, but they can send you a Facebook Messenger. Hey, deadbeat, we're the newer, kinder, rule-following debt collector, and we want to talk to you, right? So they can do that, okay? Can they send you the official 30-day notice that they're required to send you, like the first time that they communicate, right? And within 5 days, they're supposed to send you that notice that says you have 30 days to validate it and dispute it. Can they send that via text message or Facebook or okay, so two parts to my question. If they text you or Facebook with you, does that trigger that initial communication, which then does that constitute the initial communication, which triggers their duty to send that notice, number one? And then can they send that notice via an attachment to text or messenger, or do they still have to mail that notice to the consumer?
So they can always mail it and they can email it. I don't think they can text or Facebook message it. So to answer your first question, I think there would need to be some response on your part so that they know there's been a communication. In other words, they've always been able to call us, leave a message, but until there's an actual communication, they don't have to send out that notice.
But if they do send you a text or a Facebook Messenger as their initial communication, that triggers their duty to then send you within 5 days, that initial validation notice. Is that right?
I think if you respond, because that would show there's been communication, then they would have to send that.
So, okay, so then let's back up again. So then, like, prior to Regulation F, if a debt collector just sends you a letter, wouldn't they have to send that notice with the first letter because that's a communication, even if they don't know if you received it?
Yeah, generally they would. I mean, just as a practical matter, if they're sending a letter, that first letter is going to have the 1692G. But if they called you, they wouldn't, and you didn't answer, they wouldn't necessarily send it just based on, oh, we left a message for Steve.
Really? Well, let's talk about this. This is fascinating stuff. This is kind of new conversation for me. I mean, I've just always thought, I guess, that like whenever they communicate with you or attempt, I guess, so now the difference is attempt to communicate versus communicate. Are these the words that we're splitting here in our cyber courtroom, John? Attempt versus actual communicate?
It is in the definitions now.
Yeah, that's right. The devil's in the details. Okay, so really kind of based on, I guess, the law and the case law and everything, really what they've been able to defend their position up until now is that the consumer never replied back, so it never triggered our requirement to send the validation notice. Is that kind of what you're saying?
Yeah, at least that's been my experience, that they might leave you a voicemail, but not to be overly fair, but to be fair to the collectors, they don't know that you got that voicemail.
They don't know that you didn't get it though either.
Yeah. So the question is, was there communication? And so again, as a practical matter, it's when there's a conversation or you reply to something, then they would send that 1692G. But look, here's the really significant part of this law is that, and we can get into all sorts of details about like the call volume and there's a bunch of cool stuff with it. But to me, the biggest part is what they've done is they've opened up avenues of communication. So text, although there are very strict rules about that. Email, very strict rules about it. Facebook messages, social media messages. They can do ringless voicemails, where it just sort of drops into your voicemail. Okay. The point is, however they communicate with me as a consumer, I can communicate back in that same way. Okay. So before, there was a lot of question about, let's say you got a text, could you reply by text and give them information about when it's convenient to contact you? And a lot of times the response was from the courts, no, you have to call them or you have to send them a letter. Well, now it's very clear that if they text me, I look on my phone and I say, you know what? I don't want to get any text. I can just say, don't ever text me again. They have to honor that. They can't say, well, now, John, you have to write us a letter telling us you don't want to text. Okay. But it's not just like text allows me to tell them about text. I can text them back and say, let's talk about when you email me. Here are the only convenient times to email me. And let's talk about when you call me. And so I can put all that into a text and you can fill in the blank, an email, an online chat on their website, whatever it is. And they have to honor that. So think about that, Steve. They've got to, process that incoming information by email, text, Facebook, whatever, and then get that into their system to apply to all their channels of communication. And so they've been begging and whining and crying about, oh, we have to be able to communicate with all these great ways. The FDCPA is 1977, so out of date. And now they have it. And now they're starting to freak out going, wait a minute, this is not fair. Consumers get to email us and tell us when we can send them letters or when we can call them. And that's too complicated.
So what if they text you and they're like, hey, Mr. Deadbeat, we're the new kinder, gentler debt collector. We're now texting you and Facebook messaging you. We're here to collect. And you're like, I don't know who you are. Should they interpret that as a cease and desist, or how does that work?
No, I think you need to say, I refuse to pay or cease communications. Yeah. But the thing is, you can be more surgical with it. And you can say, look, only communicate with me Monday through Thursday from 4 to 6 p.m. Don't communicate with me on the weekend. They have to honor that.
So if you tell them just don't communicate with me, that should be interpreted as a cease and desist. But if you're like, dude, call me during this 15-minute window, one day a week, you can tell them that, right?
Yeah, I think you need to be reasonable about it. But
oh, wait, hold on a second. I hate to be that guy, but I am that guy. We have all these people posting up comments that we haven't even gotten to. They watch it because they know that I'm that guy that's going to go ahead and do these things. So
you're saying if I kicked you off this video, they would stop watching?
I would like to think so, but you're probably right. You'd probably double in viewership without me. Anyway, that's not the point. The point is what do you mean you have to be reasonable? So what is reasonable? Is that defined out in the regulations, or is that still to be interpreted in future litigation?
So say that again now.
So you said it has to be reasonable, the time that you tell them that, hey, please only contact me during this 15-minute window, one day a week. And you say, well, it has to be reasonable. So
that is not spelled out. I'm just saying that I suspect judges will look at that. Now, again, convenience is, I like Coke and not Pepsi. Well, there's no way to decide that. Or I like, Marvel movies instead of DC movies or whatever. So we can decide when things are convenient for us. I just think if you make it so extreme, that will signal to the debt collector, hey, something's wrong here. They probably won't ever contact you. But, for most of my clients, they want maybe, time a couple hours in the evening after work. They don't want to get these calls or text or emails during work hours. And then during, the time they want to receive them, that's when they want to get those communications. Now, it doesn't mean you have to answer the phone or you have to respond by text then. It just means that's when you're at least open to receive it. But if you don't want to get an email or a text on the weekend, you say, I don't want it on the weekend. Or, if you like watching college football on Saturdays, you can say, you can call me any Saturday except for, from, August 15 to whenever. And
don't call me on Super Bowl day, right?
Yeah.
That's no debt collector day right there. So
Yeah. So there's a lot of, really good stuff with this. And it gives the consumer a lot of control over communication. And
yeah. So what are you doing? Like, how do you see this affecting your practice? I guess that's how we were going into this. Obviously this is brand new, but have you seen anything yet kind of so far gearing up with consumers where this is benefiting them at all?
So we haven't seen collectors take advantage of this a whole lot. There's a sense in which nobody wants to be necessarily the first guy and, get shot. And so I think there's a little bit of reluctance here. But what I expect will happen is it will, multiply our FDCPA cases significantly. So, we file a lot anyway, but I think this would really ramp up the FDCPA. And what it does, I described it this way to some lawyers. Traditionally, we as lawyers have viewed the FDCPA as sort of checkers and the FCRA as chess. And this elevates the FDCPA. In a way, it makes it more complicated than the FCRA. And so instead of having 2 or 3 moving parts, now you have like a dozen moving parts.
Which, again, keeping in mind that the FDCPA was designed for the least sophisticated consumer, right? Isn't that the legal standard, like the actual legal standard of it?
Well, that's who it applies to. It's not necessarily who it's written for. It's written for debt collectors to say, hey, debt collectors, stop being jerks and abusive and lying, and we're going to treat consumers.
One of our founding fathers said something to the nature of like a law that you can't understand is no law at all. You know what I'm talking about? You graduated law school. You know what I'm talking about?
Yeah, that doesn't apply. So
that was just those founding father theoretical principles. That's not actually where the U.S. corporation sits in the year of 2021. I got you. I understand. All right. So let's get serious here, man. So it looks like we've got all sorts of questions and stuff posted.
Yeah, let's see what we've got here. Eric in Texas, we are doing well. Thank you. I wanted to know, what is the difference between negotiating with a lawyer for a debt buyer versus a lawyer for original creditor? Are their motivations different? Not really. Yeah, you're dealing with the collection lawyer. They're going to be, their objective is to get as much money as they can. Now, most of them recognize they're in a much stronger position if they have an original creditor as a client versus a debt buyer. But even a debt buyer, they want to get paid. So no real difference in motivation on the collection side. You got anything to add to that, Steve?
You got it, man. You hit that.
Right. Let's see here. So great information.
Love coming into you right there, man. Get the little.
They must not have listen very long to what we were talking about there.
There's Elvis Garcia giving you the okay sign.
Very good. Very good. All right. So here's Shadow Smurf. So do they get to use third-party mailers? And so I think what he's talking about here is the Hunstein case out of the 11th Circuit, which said that when a debt collector uses a mailing vendor, that can be a violation of the FDCPA. So we had Hunstein 1. That was the first decision. And then the panel of 3 judges reconsidered that and issued Hunstein 2. And in that case, one of the judges said, I would not have reversed the lower court because I don't think you have what's called standing, which means you haven't really been injured, and so you don't have access to federal court. The other 2 judges said, yeah, you do have standing. Well, then the entire 11th Circuit, which is Alabama, Georgia, Florida, entire 11th Circuit Court of Appeals said, we're pushing that opinion aside. We'll hear it, all of the judges. So I forget how many judges there are, maybe 11 or 12 judges in the 11th Circuit. And so they'll issue a new decision. I suspect if they decide to find in favor of the debt collector, it will be on that issue of standing, which is, did the consumer have the right to come into federal court? Because if you don't have the right to come in federal court, then they don't even reach the merits of whether your theory is right or wrong. You just get tossed out. So
what would it be that would be the argument of standing for asserting that because your letter was printed by a third party and then therefore they disclosed your information to a third party? How would you determine? Obviously, you said it was a 2-to-1 kind of a split with the 3 judges. Like, how did they interpret? Obviously, 2 of them interpreted it one way, the other one interpreted it a different way. So what does that look like? Like, how does one of them say, yeah, you've got standing, and the other 2 are like, no, you don't?
Well, it's a great question, and which I would expect from you, Stephen. So
not to be confused with all my other questions, which are also
right.
equally great, right? I got you.
That's right. That's right. Now, this issue of standing is a huge mess, and the courts have introduced this, and now it's just sort of like completely gone out of control. And the judges will look at the exact same thing, and on one side they'll say you absolutely have standing, which, to sort of boil it down, it means you have what's called a concrete injury. And then the other judges will look at it and say you absolutely do not have standing. And so how do you figure this thing out? I'll tell you my sort of simple solution to it, which I have sort of been preaching for many, many years. And that is, I file everything in state court. And then it gets taken to federal court, what's called removed to federal court. And if they raise these standing issues, I go, great, let's go back to Alabama state court. Well, maybe we don't think there's a problem with standing. I'm like, I don't care. We can go back to Alabama state court. But if you file it in federal court, then you're vulnerable to this, and it's constantly changing. And I mean, Stephen, there are cases that say if you get one illegal fax, like an old-fashioned fax, you have standing under the TCPA, Telephone Consumer Protection Act. But if you get maybe 2 text messages that are illegal under the TCPA, you don't have standing. Well, how do you square well, I mean, they try, but it's not a good solution. So it's just really a mess. And, I think lawyers that file these cases really ought to consider filing these in state court, and you avoid a lot of these issues.
Well, and this kind of brings a really good point for everybody who's watching, whether you're a consumer or a credit repair organization, or I guess even an attorney, but really not for the attorneys. But, a lot of people like to quote laws and try to be all cool when they're sending out these letters. And the fact of the matter is really what your duty is as a consumer or a credit repair company is to find the errors or the issues or stick to the facts, right? The interpretation of the facts, to John's point, this thing went all the way up to 3 judges, and 2 had one idea and another one had another. And let's just look at the Supreme Court, right? It's never a 9-0. It's usually 5-4, or 6-3 or something. What that means is whoever knows what the final interpretation is going to be. I mean, there's so many variables. And that's where, if you're trying to dispute your own credit, really get good at finding the errors or the factual issues, just put it in plain English, send them whatever your complaint is, and let the lawyers practice law, because, people are like, oh, you violated the law. Well, to John's point, 2 judges thought one way, another one thought the other. You never know which way these cases are going to go. So the best thing that we can do to set ourselves up for success if we're trying to go to a lawyer is just to keep it simple. What are the facts? How do I feel about the facts? And, if it's the FCRA, hey, they're supposed to report accurate data. Why is it not accurate? We don't need to be like you guys, pursuant to so-and-so court case have completely jacked me. No, let John make that decision on how he wants to frame it up and send it over to the package it up in a court case. So anyway, John, sorry, go ahead. I wanted
No,
to
no,
get.
no. I think that's great advice, because if you start saying, like, I'll see these letters floating around that will have something about, pursuant to, Judge Smith of the Eastern District of Tennessee who said this. I mean, that's kind of like saying, well, I remember in a certain Super Bowl they did a sweep around the right hand side and scored a touchdown, so that will always work. No, it worked in that particular situation under those circumstances. So I would not try to get bogged down in the law. Just find the things that can't be right. So you're looking on your credit reports and it says, and to me, this is always sort of an interesting thing, Stephen. Equifax will give you the date of first delinquency, right? And they'll say that date is June 2018. And then you go look in the payment history, and for June and July and August, it says current of 2018. You're like, well, now, how's that the date of first delinquency if I was current then? So find stuff like that. Don't say, well, I think pursuant to this case law or this statute, you're reporting this wrong. Just find the stuff that factually is not possible or inconsistent or incorrect, and that will put you in the best possible position. Let's see here. We'll try to catch up on these. A debt collector never served any papers. Fighting for my name back. I got mail saying I was sued. So it sounds like you may have been sued in the past, and maybe you're being sued in a new case, or maybe it's in the original case and now there's some garnishment or something. So I would get with the lawyer in your state and have them look in the court system and find out, is there one lawsuit against you or two or three? And if somebody says you've been served, how were you served? They may have said, oh, we served you at 123 Main Street. And you're like, I haven't lived there since 2010. And so you got to figure out where you are. Steve, sometimes we call this the GPS method. If you want to use a GPS, you first have to figure out your current location, and then you figure out where you're going from there. So that's what I would do. Let's see. Okay, victim of identity theft, FCRA about to be involved because proof of residence. Appreciate this live. Well, you're very welcome. And if you're a victim of identity theft, you definitely want to notify the bureaus, so Equifax, Experian, TransUnion, and whatever the furnisher is, the credit card company, auto loan company. And, you can go to FTC. They've got identity theft information there, and that can be very helpful. Let's see here. You'll probably all need to agree for them to publish an opinion. Well, and so on this Hunstein thing, it sent shockwaves through the collection industry, and they're just like going crazy over this decision. So I think the 11th Circuit will issue a full opinion. If I had to bet what they would do, I think they will affirm the lower court. So the trial judge said, this is not a violation of the law. I'm throwing the case out. It was appealed. The 11th Circuit reversed it. And then the second opinion came out. They still reversed it. Now the full court's going to decide it. I suspect they will affirm the decision. In other words, not reverse it, but it will only be on standing. I don't think they will address whether it's a violation of the law. To me, it's clearly a violation of the law. They've disclosed your information to a third party without your permission. And that's been illegal since 1977. So I just don't think we'll have
outdated law, 1977.
Yeah. And let's see here. We got Muriel. Good evening. So good to see you. And let's see. Collection account statute of limitations expired within the client state. Can the collection company continue to report it, try to collect if statute of limitation within their state? Yeah. So what I would say about this is I have to keep in mind there's a couple of concepts here that are not necessarily related. One is statute of limitation, how long to sue. And the other is what do we call it, Stephen? The obsolescence period. in the FCRA, basically 7 years from when you defaulted. And so the statute of limitation might be 1 year or 3 years or 27 years. That doesn't affect the time period to credit report. So you sort of keep those separate. There's the time period to collect against you, which in a lot of ways is unlimited. The time period to sue you, statute of limitation, and the time period to credit report, and that's under the Fair Credit Reporting Act, 7 years. And let's see. You take client referrals, work on a contingency basis. So yeah, we do. Just you can get in touch with us and be glad to chat with you there. Muriel says, my credit report, they're different last payment dates. So Stephen, what would you say about that? If, let's say, Equifax has date of last payment June and Experian has July and TransUnion has August, what would you do?
Yeah, I would want to make sure that I'm looking at the actual Bureau direct reports for something like that, because the credit monitoring reports are great sources to kind of get initial passes and even do disputes. But so are you saying like it shows different days within the same month? That could just be the way that the credit monitorings pull the data together. If it's like different months altogether, that's probably not the credit monitoring changing the data. That's probably that at the bureaus is different. So I would say, take a look at your annual credit report or the paper reports you get directly from the CRAs. And, if they're different there, well, there's a problem because there can only be one last payment. Then you would want to look and see when was it most recently updated with each of the CRAs. I mean, was it refreshed 2 years ago at one CRA, but last month at another? That could be a reason why one is showing 2 years ago date and this one is last month. That would probably just be fixed when the Bureau refreshes it, and they should pull in all 2 years of history that's missing at that point in time. If they missed 23 months and just put last month and have a big hole, now it's inaccurate, incomplete reporting. But so are they all reporting as of the same month? Are they all, freshly reported? And are the dates actually different on the Bureau direct reports? And if they are really different, then I would say that you've definitely got inaccurate information.
Yeah, I think that's great advice. So definitely check that out. Let's see. Eric says, when settling a debt case, do attorneys for the creditors want to see hardship before they agree to a lower amount? So that depends. A lot of times they have a certain authority. It might be 80%, 70% that they can go down to without any documentation. But if you want them to go below whatever their authority is, then they may say, I need to see hardship information. And here's where you have to make a decision. Typically, what they require is all your financial information. So your income, where you bank, all those details. The concern for a consumer to give all that information up is you make it very easy for them, if they get a judgment against you, to garnish your wages, garnish your bank accounts. So you have to decide, do you want to do that? And if you do, just understand you're taking a little bit of a risk with that, but that may get you the settlement. What they typically are more concerned about is, are you paying in a lump sum? Well, that's always very attractive. Okay. If you say, well, I can pay you $50 a month, so how much will you come off the $10,000 I owe? Well, it may be zero, or they may say, we won't even take that. We'll just go get a judgment. And depending on your state, they may garnish you 25% of your take-home pay, or put a lien on your house, or wipe out your bank account. So you just have to kind of figure out what you can afford. And this is the way that I do it. And Grant, I have a relationship with these lawyers, and they also know if they say no on an original creditor, because I don't ever pay any money on a debt buyer, but an original creditor, if we're offering them something and they don't take it, then we'll go to trial with them. So that's kind of the threat. But I just say, look, this is what my client can do. You want to take it? You want to not take it? And, I think you're better off just being very upfront. So in other words, if you could afford $400 a month, don't tell them you can do $40 a month. At least I wouldn't do that. I'd be like, look, this is what I can do. and when they see that's reasonable, hopefully they respond appropriately. And if they are unreasonable, you don't settle. Let's see. So Queen Chilling's one that had the lawsuit identity theft. So there's a lien on her house. So that's got to be from a lawsuit. Yeah. So you really need to get with a lawyer in your state to find out, were you properly served? Because in most states, I think every state, you have to be properly served to then have the clock start running for you to answer. And then you don't answer, then they get a judgment. But it's kind of a constitutional thing. You have to be served in order to have a judgment against you. So I would definitely check that out.
So John, do you know offhand, like how many states, like in Texas, the Texas Constitution kind of protects your homestead? You can't get a judgment. If a debt collector sues you for a trillion, quadrillion dollars in Texas, it can't attach to your house.
Oh, really? Okay.
Yeah. So do you know like which? I mean, I guess that sounded like a surprise to you. So I guess that means you don't even have an answer. I was wondering if you knew of other states that are.
Yeah, I mean, I do know of other states. So I think like Arizona, maybe you can protect something like 100,000 per person on your house. So if you're married, a couple $100,000. Florida, I think, is unlimited. That's why you see the singers, movie stars, they'll file bankruptcy and they keep their $20 million mansion because it's protected. Alabama, it's 15,000 that's protected.
Woohoo! Go get your little stick hut out there, huh? Keep that property value low.
Yeah, it's not very impressive. So you do need to know what your state is. And I think in Texas, do you guys have wage garnishment in Texas? I don't think y'all do you?
I don't even, you would think I should know. I don't. You called me out on that one. I have to go back and look and see what that one is.
I think there's no wage garnishment in Texas.
Yeah, I don't think so. That's what I'm like thinking, because I haven't seen that. So I'm just thinking like, does it not exist, or have my clients just been lucky? That's like where I'm thinking here,
Yeah. So, it is important to know what are the worst case scenarios. Okay. If they get a judgment against me, can they touch my wages, my bank accounts, my house, my car, that type of thing? In a lot of states, the answer is yes to all those. And so you have to factor that in.
So Queen Chilling, what you should do is get you some firearms and head to Texas and get you. That's why all the super wealthy people, they put all their money in their homes, in their homestead in Texas, because it's kind of like protected under the state constitution. So
here's one. This is an interesting question from Roger. How do you deal with Freeannualcreditreport.com when none of the questions they ask are correct and they won't give you your reports?
Oof.
So I've got a few thoughts, but I'd love to hear yours, Steve.
That's a tough one. What you could do is there is an 800 number for annual credit report that you can try calling. It's like a digital system. So that usually you should be able to go through the phone number, and then what will happen is the bureaus will mail you paper copies. So that would be the backup that I would recommend. And as an alternative, you can mail in to the CRAs a request for your full file disclosure, and then they'll mail you the paper copies. But I mean, as far as actually getting the digital one from the website, yeah, if you can't get through there, they've got you locked out.
Yeah, and here's the challenge. So you get a free credit report, or technically a consumer disclosure, every week from annualcreditreport.com, but that's only online. And when they have it kind of messed up in the system where they won't let you get the reports, if you say, well, mail me a copy, they go, oh, we mailed you one 6 months ago, so you're not eligible. So it can be a pain. You can always write to them, sort of explain what's happened and say, I want my full file disclosure, which they would say is the same thing as a consumer disclosure. It's not really, but we won't go down that rabbit trail right now, but at least you can hopefully get your report. A couple of workarounds: you can sign up for Experian.com and it's free. Now you just have to watch the upsells on it where they're trying to sell you credit scoring and this and that. But you can get free reports from Experian.com, MyEquifax.com. You can't get it in a nice PDF. You have to kind of look at each account individually. But those are two workarounds. Stephen, I'm not aware of any free TransUnion where it's actually TransUnion.
Well, you can log in. Yeah, so there is a link directly where you can log into TransUnion and the other two bureaus directly with them. And it's not like one of their paid services, and you can get, so I guess, yeah, I should have mentioned that. It's not the annual credit report site, but each of the three bureaus do have specific links where you can log into, and it is their direct free credit file disclosures. So in fact, let me
If you
get that link here. Let me
see if you can pull that up, because I looked for that one time because I thought that existed and I didn't see it. So I'd love to.
Let me pull it up here. Okay, here I've got two links that work. Here is one of them. I'm gonna.
You want to share your screen?
How do we? Well, I'm gonna just post it up here, I guess. I don't know.
Okay. Yeah, if you put it in the
No, I
comments.
can't post it because I'm not the host. So, I'm gonna send it to you in Facebook Messenger, John. We're gonna go old school here. That way, you can go ahead and. Okay, there's one of them.
Let's see.
And get the other one here. All right, so there you go. All right, John, there you go. You've got the goods.
All right, let's see here. So
Look, I could hear it dinging. It like took virtually no time to get from Texas to Alabama, man. That is
it's pretty quick.
Fast travel right there.
So
All righty.
all right, let's see if this will post up. I don't know.
Look, John's trying to
a little
multitask. How do you guys like that, huh? All the fans comment on what it's like watching the esteemed John West try to multitask. He's trying to open a link and talk at the same time.
Yeah, it's painful, man.
It's a rough one. Oh my God.
Yeah, so we'll just throw these in the comments. Hopefully they will pop up here. Let's see. Now I've lost my place. So not only can I not multitask, but then when I try to go back, let's see here.
Dude, you got issues, huh?
Yeah, that was never in doubt. Let's see, license all 50
Nice.
Well, I'll say this, Sammy, and that's very kind to say. There are consumer attorneys. You can look at NACA, National Association of Consumer Advocates. There are some really good lawyers in the in Stephen's paid group. And so we got people in New York and California, Tennessee, Florida, probably missing somebody, Texas. And so there are some good folks around, and we do try to do training for people. Let's see. Queen says Equifax had me as dispute 2 years, no results. Yeah, what you probably need to do is not only get with a lawyer to find out about that lawsuit, but also a lawyer that deals with credit reports in your state. And again, you may want to go to NACA, which I will post this on the screen here. So consumeradvocates.org, and then find an attorney. And that can be a useful place to go.
Who's that good looking guy on the left side of that picture right there? And
I don't know. I think that's
the
my
red
son.
tie, the power tie, man. Look at that guy.
Let's see here.
That must have been back when you were young. That picture over there. Look how skinny you were, John. My goodness.
Yeah, I know. Yeah, it's the COVID weight has been added apparently.
Whew, I tell you, you're telling me, man. Good thing I've got these stretchy jeans, and I'm like, good thing my jeans stretch, because if they didn't, it would be a tough deal right there.
You didn't know your jeans had turned into spandex, huh?
It's Levi's. They've got these. It's this new stretchy material. It's like it looks the same, but it feels a lot more comfortable when you have that COVID weight on.
There you go.
We digress. All
right. So let's see. Eric, settlement agreements or specific language added refers to how credit reports should be updated. So I'll tell you my experience, Eric. The original creditors typically won't do anything about this. In other words, they won't agree to delete it. Not saying it never happens. Typically, they won't do it. They probably, if they say anything, will say this will be updated to show that it's settled in full for less than full balance. The debt buyers may say they'll delete it. Typically, portfolio deletes. Midland sometimes will. I'll tell you this, I actually prefer it to say nothing about credit reporting, because if I've been sued and I settle, there's going to be a dismissal with prejudice, and I'm going to take that order along with the lawsuit and go to the credit bureaus. And so I don't want the settlement agreement to say anything, because I'll deal with it directly with the bureaus and say, look, I got sued, case is dismissed with prejudice. Either if it's a debt buyer, get this off of my report, or if I paid an original creditor, show it as a zero balance. Because a lot of times what they'll do is, let's say you owe 5 and you paid 3, they show your balance as 2,000. They just do the math. It's supposed to do the math, Steve. You're supposed to actually show it 0.
I get in trouble after 10. That's math wasn't my strong point.
So here we have somebody who is in desperate need of seeing an eye doctor, I think.
Well, so, Matt Hearn, it takes a handsome guy to recognize handsome guys.
I mean, look at that profile picture. That's like just coolness coming out. So I got to get that off screen. That's.
Well, he wants to be like you. I mean, you don't underestimate your level of coolness, John G. Watts.
Let's see. Had to request in writing a bill, my name, picture. Okay, that's a good idea. And we should have said this, and I appreciate Jay Martinez pointing this out. When you do send it in writing, it's helpful if you say, here's my driver's license, and it has my address on it. And here's, for example, utility bill, that's best, maybe a credit card bill, insurance statement, bank statement. And then they'll get you hopefully sort of fixed in their system, but it can be a pain. And so I'm glad it worked out. Jay Martinez doesn't always work out where you can pull online, but certainly that can help here. And let's see, collection company can now DM you. Yeah, they can, but there are some limits on it. And again, what the collection companies have realized, I mean, they were so excited about this. They've been begging and begging for this, and it's getting closer, and we're so excited. And then they got to a certain point where they go, oh my goodness.
You know why that is?
What are we going to do?
It's because evil never ultimately prevails, and debt collectors are inherently evil. So now that they got what they asked for, we're going to use that against them, right? Right, John Watts?
That's right. Now let's see, Mariel. So my I don't know if that's Spanish, but my Spanish is not any good anymore. So let's see.
I don't know.
Small claims was 1. My Credit Karma, it says still open. Recent mail, how'd they find my new address? Just to say they won when I've never been served. Attorney is best. Yeah, absolutely. Get an attorney. Stephen, why don't you answer the question? How do these credit bureaus know, like, immediately when we move and get a new address? How do they know that?
Well, because they have everybody's information. I mean, it's hard not to have that information public. With the post office, if you move it, if you ever change any of your bills, I mean, there's going to be somewhere, you change your utilities, something like that. And you could hire a good skip tracer and they'll be able to find that. It's amazing how quickly that information moves around the world. It's wild.
Yeah. And if you ever want to be completely freaked out, pull your LexisNexis report and it'll tell you like your neighbor's dog's name, and it's a little disturbing. Let's see here.
I think that wasn't Spanish before. I think that was her auto text thing, because that's the same message, I think.
Okay. Yeah. I certainly have sent stuff where I'm like, man, that was a brilliant message. I look down and I'm like, what in the world, Siri?
That's right.
Probably shouldn't say that. It'll like start my phone here. But let's see. Queen is in California. So yeah, there a lot of consumer lawyers in California. May want to get with Mike Cardoza in Los Angeles, and I think he'll be glad to help you here. Let's see, Jay Martinez, only wage garnishment by court order for unpaid child support or spouse. Okay, and that makes sense. I mean, if you owe child support, alimony, that's fair game. But it sounds like nothing else as far as a collector being able to garnish. So that's good. Um, let's see. Somebody here got a judgment against Phoenix Financial E8. So an E8 violation is FDCPA when you tell the debt collector. It actually doesn't even have to be you. It's just if the debt collector knows or should know you dispute an account, they have to mark it as consumer disputed. And if they don't, it's violating E8. So the section E8 of the FDCPA. The only sort of caveat is if they know you dispute it and they never update, most courts say that's not a violation. So they have to update and not mark it as disputed, and then you have the violation.
Well, let's touch on that real quick. And the reason is because it's the reporting of false information, including not marking disputed debts. And so if they don't update it, they're not reporting. They reported previously, but they stopped reporting, right? So, and under the FCRA, it's pretty clear with the precedents that they can stop at any point in time. Now, if you dispute it and they stopped like 2 years ago and it's still an active account and you dispute it, what's supposed to happen? The CRAs are supposed to reinvestigate and record the current status at the result of the reinvestigation. So if you have a trade line that hasn't been updated, you dispute it through the CRAs. They then reinvestigate with the furnishers. The furnishers at that point then are supposed to properly update it with like the last 2 years of missing data. And at that point, they should put the disputed months for every month that it was disputed. But if you don't dispute it and they're no longer currently reporting, it's just kind of aging out, that's okay as far as credit reporting accuracy requirements.
Very good. Very good. So we've got student loans. Can they send you to collections who will do a hard credit pull? So let's sort of broaden that question. It's a very good question. Can a collector pull your credit report, Stephen?
Yes.
Okay. Yeah, and that's the right answer. Technically, they can do hard pulls.
Yes, I got the right answer, John. Give me a cookie, man.
You know, we used to see that more. It's very rare now that you see a hard pull on collection. They typically do soft pull. I suspect they didn't like people like coming unglued on them, for doing hard pulls. And so they will do sort of like an account review, or they'll make it a soft pull so it doesn't.
They were like, oh, we don't like this consumer. We're going to do a hard pull every single day to drive their score down. That's what you're saying they don't do anymore, huh, John?
I had a case like that where the collector threatened my client, like, I'll pull your credit report every day and drive your score into the ground.
Oof.
So
you mean they can't lawfully threaten to destroy your credit because they maliciously just want to get back at you? There's laws that protect the consumers against activity like
apparently, yeah. They went away after paying a nice sum of money and never touching our credit report.
Yeah, but we joke about it, but in actuality, that's kind of part of the behavior that drove the FDCPA to be created, right? All kidding aside, right. Because debt collectors weren't formally regulated. I mean, you still have claims that you could try to sue them for back in the day, so far as abusing you and stuff like that. But there was no statute that said, okay, now you guys are regulated. You can't abuse this poor consumer.
Yeah. Well, it's, Congress looked at it and said, it's right. It's built right into the statute. There's abundant evidence of abusive debt collection. So it wasn't just isolated. And
you mean that is an abusive industry? I mean, their websites for their trade associations and everything talk about all of the defaulted money that they collect and bring back into the economy. And if it wasn't for the ethical debt collection industry, our economy would crash and crumble and screech to a halt.
Here's the funny thing. The FDCPA talks about one of the purposes of it is to protect debt collectors. Well, protect which kind of debt collector? Those who follow the law. Because, and I made this point in a closing argument to a federal jury one time, that the crooked debt collectors that break the law, they're cheating in the sort of the world of competition against the honorable debt collectors. It's like playing football and you're like, well, I'm going to have 13 guys on the field. Well, that's not fair. You get penalized for that.
It's like boxing with Mike Tyson, and he just decides to bite your ear off. I mean, that's just not a
That's the
fair
old
way.
Mike. Well, that's the old young Mike Tyson. The new old Mike Tyson would never do that. He would
Now he
he'd
likes to
probably share some
now he likes to hang out with
mind altering substance with
he
you.
hangs out with his pigeons and doves now and does
Yeah, yeah.
commercials.
But if you ever made him angry, he could still kill you. So
Yeah.
be careful
All
of
right,
that.
we digress, don't we?
All
Let's
right.
get back
So
into it here.
pay status reports repo well after vehicle was sold and account charged off. That's a very interesting question. So what do you say about that, Palmieri?
I guess I'd like, this is Miles. Thanks for the question there. I mean, like, are you saying that it's reporting something after it was charged off, and then after a few months or years of something, then it goes to repo? Or um, like, because if it shows like repo every month after that, I mean, that's it should be closed out with a final status once the account is closed. I mean, so they should not continue to report it like after it was done. So I guess I'd want to take a look at the report and just kind of see what the details are. I mean, feel free to message me, and then maybe we can even review that on the next episode. But I don't think I've got enough information there to kind of figure that one out totally.
Yeah, and typically, the sequence is they repo and then they send you a letter saying we're going to sell in the future, and then they sell it, and then they send you a letter that says, hey, in the past we sold it. Here's what you owe now. And sometimes you'll find the credit reporting kind of gets stuck back on the original amount that you owed, even though they've now sold it and that amount's been reduced by $5,000. So, yeah, let's take a look at that report.
The way you just phrased that, that's the kind of way that I can see you present these cases to the jury. You're like, sometimes, jury, the credit report just gets stuck back. Like you just so simplify it, like, hey, no big deal, but we're going to have to find them guilty,
We did try to find them guilty.
That's right. Put it in terms that the jury can understand, right?
So here's somebody, I don't know who this is. You may know who this is.
That is our good friend Warren Maxwell.
Well, that doesn't surprise us at all that Warren, he's very free with taking shots at us, but he's such a good guy that, you love him anyway. So.
Well, one thing I can say is that I do have a lot of my clients, friends, and super fans that send me Uber Eats. By the way, if you guys are interested, I'll send you my address, no problem. But the reason why Warren posts this is because on his conscience, he knows he's never actually sent me Uber Eats. He hasn't contributed to my expanding waistline.
Is he trying to justify not sending you?
That's right. It's his conscience getting to him. That's right.
Yeah. So let's see here. Let's see. A year after defaults, I'm seeing FICO score go up every month for any settlements. Will it peak or continue going up? What do you say about that, Mr. Stephen?
So I'm assuming that it still has a balance and that it's not been zeroed out and sold to a debt collector. I guess that's going to be my assumption. So, I mean, if this thing has no activity on it and starting to age out, then, the older it gets without any activity, your score will pop up. Now, if you were to make a payment, that will be fresh activity on a negative account. And although it's counterintuitive because you think, oh, well, I'm doing the right thing, morally, I'm paying these people. Yeah, the FICO score does not care about morality, unfortunately. And so when you have a charged off account, John Watts, what is so funny over here, my friend?
Yeah, I've never heard it stated that way, but that's great. FICO score doesn't care about morality.
That's right.
I like that.
I continue now. So the score doesn't care about morality. So when you have a charged off account, that is a negative account by nature. It can never be made unnegative. You can pay it. That'll change the balance field from having a balance to a zero. But the status can never revert to anything good, right? Once charged off, it's always perpetually, forever and ever, amen, charged off, right? So it's a negative account. So the issue is that if you were to make a payment on a negative account, that is fresh activity. And part of what affects your immoral credit score is recent activity. So if you have recent activity on a negative account, because the score is way recent activity more than old activity, you could actually drive your scores down by paying. And this is the same for debt collection accounts, right? But any negative account, if you make a payment, that could actually drop your score. So from a credit scoring perspective, you're actually better off not paying these people unless you can get a pay for deletion. And then, from a not getting sued perspective, it's probably better to either pay them or call John Watts so he can sue them and get you paid. So there we
Well,
go.
and just to add a little bit of extra complexity, it does depend on which FICO score, right? Is it the new FICO score, the new FICO score, the old FICO score? Do they count paid collection, not count paid collection? So what I always suggest to people is, if you say you're looking to buy a house, talk to your mortgage broker, based on the score she uses, not what the guy next door uses, but what does she use? What will happen if you pay off this account? Because it could be two different answers, which again just makes it more confusing. And you see people out there sort of ranting and raving like, I've got this absolute gospel truth on this. And well,
John Watts, I've got a question for you. I can tell that you do things for the love of the game and to help consumers, but on the same time, we're all driven by money. And nothing would pay you more than being able to file a class action against these big giant corporations. Could you see yourself putting a suit against FICO for a credit scoring model that if you pay, do the morally right thing and the legally right thing, a negative account, it actually drops your score? That seems to be some sort of a flaw in their algorithm that is not predictive of your true risk. Why would my credit risk increase, which means a lower score, if I'm actually paying these people? Help me out with that one, John.
Well, now you're out money, so you're more vulnerable.
John, you're clearly not the guy to go ahead and do a class action against FICO.
Yeah. Actually, I don't like class actions anyway. Let's see here. We got Miro. Yeah, auto detect acting up. I tell you what, I have made the mistake of, have you ever dictated a message and you think you are speaking clearly, and then you look at it like an hour later and you're like, oh my goodness, what did I send to that person? So let's see. Yeah, collectors can direct message. Yeah, it's really November 30 is when technically they could start. I think they're going to kind of slow roll it out. So a very good comment there. This is an interesting one. And actually, we were having some discussion among some of the lawyers in the Facebook group about this. So let's take a collection account. And clearly, Steve, you dispute the account. I mean, no question about it. You send a certified mail letter, I dispute this account. Where and how should that be marked as disputed? Is that in the remarks, the comments, the status? Where should it?
Yeah, there's a field, a special comment field where you would have. So there is a field actually. If you look at the Metro 2 manual, where you've got all the codes for different types of dispute. So there is a field where it is supposed to go. So if it's not in there, then the field that their industry standard has set aside for it is clearly not being used, which would make it inaccurate.
Very good. Very good. Let's see. Jared says schedule live Facebook. So we normally do this at 4:00 Central on the second and fourth Thursdays of the month. And I get confused because I have it on my calendar like every 2 weeks. And so I'll be texting Steve and like, hey, the show.
John, you've been doing this for almost an entire year and you haven't gotten your calendar.
No, it's, I just sort of adjust it every time there's like 5 weeks.
John,
and you're
what are
like,
we doing here?
No, it's Doug Miner this week. Just go away till next week. I'm like, okay.
That explains why I text you half the time and I'm like, dude, are we good for our show tomorrow? And you're like, oh no, I got to be in trial, because you didn't have it on your calendar. You never told me that before. Now
you know.
Now I know, son of a gun. You clearly are not committed to our audience. I'm not upset, except that I'm upset for our fans who you're not giving them the proper planning that they deserve.
But good question, Jared. And actually, Jared, I need to chat with you. If you don't mind, text me sometime tomorrow. Let's chat. Let's see. Jay Martinez got a collection recently, although it says disputed in the notes, it still hit my score. So it's a very good observation. Traditionally, we have always sort of said, although there are exceptions, but if it's a collection account that's disputed, that the scoring models normally will skip over that. So what's going on, Stephen?
Well, so I am not a score expert. My assumption would be, I mean, there's Vantage scores and there's lots of different FICO versions. So my assumption would be that whichever score version you're using, uh, it is calculating it. And even if, you know, some of the scores where it does calculate it, like for mortgage purposes, they may still require, if you're trying to get a mortgage, you know, that it doesn't show in dispute, just to make sure that they're, you know, they are getting a true score. But somehow or another, it is affecting the score. And it's probably just a different score model.
Yeah, and it always could be that there's a coincidence where you get this collection account and something else has happened, and that's what's affecting your score. You know, you can do something like Credit Karma, and while that's not your FICO score, it, you know, the hope is that it's what's a fancy expression, Stephen? It's directionally accurate. You know, it may not be like the number itself, but hopefully if it's going up or down, that's accurate. You can also, some of your credit cards may have a FICO score that you get for free, or you can sign up for myfico.com. And I want to say that's maybe 30, 40 bucks a month. And you can track it a little more precisely with that. Let's see. Debt collector called my old number saying I owed money on an account. I filed a police report for ID theft years ago. They said there was a forced judgment, but I've never been notified. So that would be similar to what we chatted with the nice lady from California about, that you really need to get a lawyer in your state to look and see, is there a judgment? And now if you've changed states or something, you may have to get somebody in your old state to look at this. And were you served? And here's where it gets a little tricky. And Stephen, I think you know this, but it's sort of counterintuitive to us, because we always talk about, you got to be properly served, properly served. And people think, well, that means it has to be handed to me. Not necessarily. So for example, in Alabama, and most states are this way, if I want to serve you by certified mail, then you have to sign the certified mail. If I want to personally give it to you, I have to personally give it to you. But if I take it to where you live and I hand it to basically an adult who lives there, not talking about your cousin visiting for a week, I hand it to your roommate and they promptly throw it away, you're still served, even though you didn't know about it. So that's why we always say, you know, you have to figure out where you properly served. And
So let's talk about these though, because I know the other lady had posted up about ID theft, and we kind of glossed over that part. And here he's saying, you know, police report ID theft. Okay, so I think there's kind of a couple parts to this conversation. There's the identity theft. I guess there's three parts: identity theft, credit reporting, and then the judgment. So first, let's talk about the ID theft. So forgetting about the judgment for right now, but if you have a financial account, a credit account that is fraudulently open, okay, it's not yours. That is, there is a specific part of the FCRA that deals with that. It's not the dispute portion. So there's a separate portion that requires the consumer to get a police report, or a police report, or some official government report, like if you're in the military, you know, go to the whatever it is there. But basically a police report, and then put together an affidavit and send the police report, the affidavit, and proof of your identifiers to the bureaus. And then they are supposed to block the reporting, basically delete the item within 4 days of receiving that. The exception is that if they believe what you sent them is fraudulent, like if you're just lying to them, which, believe it or not, a lot of people do. A lot of people send bogus fraud disputes. John, I know none of your 17,000 viewers would ever do that, but they can reject your letter if they believe what you've sent them is not true. Okay. But in your case, okay, I mean, if you're sending this, so that really ties to why a lot of attorneys love these cases, is because if yours is truly legit and you send them a notarized affidavit that says, hey, these trade lines are the result of ID theft, and here's my police report, if the bureaus do not block it within 4 days, that is like just ripe and juicy for attorneys. Those, correct me if I'm wrong, I'm not an attorney, but those are kind of like maybe 6-figure type cases, John. I mean, is that right? Yeah. So just for you guys watching, if it's real, true, bona fide ID theft, police report, notarized affidavit, mail it into them, certified mail, and just wait for them to screw it up. If they don't, hey, good news. Then they delete your credit and you're good. What also is supposed to happen if you put the bureaus on notice of identity theft, interestingly, what I'm about to tell you is not triggered under the FCRA if you dispute with the furnisher for identity theft. But if you send your notice of identity theft to the CRAs, they're supposed to forward that to the furnisher, and then the furnisher is supposed to cease collecting and is prohibited from transferring the debt. Basically, it kind of kills the account. And part of that is why the bureaus are always kicking these fraud affidavits back, is because the effect of them accepting it is that under the FCRA, the furnisher can no longer collect on that debt. Right, John? Am I misspeaking here in any way?
No, I think that's right. And let me just sort of say this warning, because this is where the scammers and fraudsters come in and say, oh, we can do this credit sweep, of all of your negative account. Fill out a false police report. It's a felony. Do a
Big
false
problem.
affidavit. And, it's just, you don't want to go that route.
Yeah, I mean, basically, you're committing fraud, if you're doing
Yeah.
that. But this is legit. So that kind of takes care of the credit reporting, the FCRA. So then the question is, okay, so let me ask you, John. So for our viewer here with this issue, if he was allegedly never properly served, but then this thing went to court and then there was a judgment, but the judgment was rendered on a debt that was fraudulent. I know judgments kind of change things. It's like a whole other type of a permanent type ruling. But I mean, aren't there some basic principles of our legal system where, if something is fraudulent, then you're not even, like you have no responsibility for it. Like, what are his remedies? Because I know the judge ruled on it, so that's kind of like too bad, so sad. But is there like a statute of limitations for him to go back potentially and say, number one, I wasn't properly served, and number two, this isn't even my debt? Like, once it goes to a judgment, what does that part of the process look like?
It certainly is harder. Okay. Now, most states have numbered rules of civil procedure, like rule number 1 and rule 4. And there's typically in each state what's called rule 60. And that's where you can say, let me change this judgment. And one of the sort of subcategories is this was fraudulent. Okay. Now, that's more of somebody committed fraud on the court as opposed to, fraud against you. But, find out, were you properly served? What about the credit reporting? When did you find out about this? Because it may be that technically that judgment stands, but you may have a lawsuit against the company behind that judgment that is worth many times more than the judgment itself. And so they end up paying you money and telling the judge to get rid of the judgment. So
this is fascinating. Let's not just gloss over this. So I guess number one is what we're talking about here, state-specific laws in general. Okay. So then is there, let's say that they get the judgment and there's no activity. There's no collection action on their part at all. It's just hanging out there. Is there generally a statute of limitations after which, you cannot go, because you just said, hey, well, you could try to sue the original creditor who got the judgment, right? But I mean, is there a statute of limitations, number one, from the time of judgment if there's no activity? And then if so, then if they try to come and collect, would that kind of like restart the statute, which would let you counterclaim them or something like that?
So typically your lawsuit would be under the FCRA or maybe the FDCPA if it's a debt collector. So you're going to have some activity on the credit report, or like you were talking about, you had to do the notification of the credit bureaus properly and send the ID theft affidavit, the police report. So it gets a little complicated because now you are merging state law, which is very state specific, and federal law. So I would say you've got to figure out where you served. Is there a judgment? on that police report, identity theft, did you send that only to the company or did you send that to the bureaus? And if you sent to the company, did that same company get the judgment or did they sell the debt and then some new company actually got the judgment against you? So there's a lot to unravel there, but certainly it's worth looking at and figuring out, what exactly your situation is with it.
Well, let's set aside the credit reporting altogether. Let's just say that the judgment, the debt itself, that they're trying to collect on you. I mean, so would there be a limitation period, if they all of a sudden are trying to collect from him? Because you had said, hey, well, he could very well have a claim against whoever's trying to collect. I know you can't speak for all states, but I mean, in general, okay, the judgment was rendered on whatever this particular day. Is there typically a statute of limitations from there for you to claim fraud as a defense or whatever? Or, how would that work in general, regardless of the credit reporting?
Yeah. So under Rule 60, I'm trying to remember what the timeline, because there are different parts of it. Some are 4 months. One part, there's unlimited. That would be like, for example, you weren't properly served. So I've had clients that had judgments 15, 17 years ago. They just find out about them and we get rid of those judgments. Okay. There is no time limit if you weren't properly served. But just in terms of like, do you have a state law claim against a creditor for getting a judgment against you on a fraudulent account? Generally, no, because the judge ruled that you owe the debt. Okay.
Now,
let me just say this one last thing. You add even more complexity to it because some states view default judgments as this is proof you owe the debt. Others view it as it's no proof you owe the debt. It's just proof you didn't respond. Maybe you chose not to respond. You're like, it's not worth it. So we start to get, if you've ever read the book Dune, it will talk about like, deception within deception within deception. This is like, complexity within complexity within complexity. So I'm not aware of sort of a typical state law claim you would have. Normally, when we're bringing state law claims, it's when we have one. So we sue for malicious prosecution or something like that. There's a cause of action called abusive process. But again, generally, we have to win to be able to bring that. So in this situation, we're talking about we lost. And if we were properly served, that judgment tends to stand unless we can meet that Rule 60.
And if they try to collect, I mean, so they've already sued you, there's a judgment in the post judgment collection process. I guess that's what you guys call it, right? Mm-hmm. Would there ever be a reason for them to resue the consumer, or is it all just go into the court and hey, I want to garnish this guy's wages or whatever? Because where I'm going is like, if they were to resue you, then you could try to counterclaim them. Is that a reasonable statement?
Yeah, they typically would not resue you. I mean, they have the judgment. Each state has a certain period of time you can collect that judgment. So the judgment is valid. After a certain period of time, the judgment becomes unenforceable. Okay. And I mean, I've seen that as short as like 3 years and as long as 20 or 30 years. So very state specific on that. So let's see here.
Interesting stuff.
Yeah. So here's a question. What are typical damages for an E8 or CC claim? So these are under the FDCPA. So E8 again is where the collector knows it's disputed. They update, don't mark it as disputed. CC is where you say cease communications or I refuse to pay, and they continue to communicate with 3 very limited exceptions. So the damages, sometimes those are just what we call statutory damages, which is basically $1,000. If you can show that this was upsetting to you or this affected you monetarily, and those are 2 separate things, then you can get more. And I will say this, a lot of these claims, the value really comes from the attorney's fees. So, somebody says, well, I'm going to file one of these, and, collector may say, all right, I'll give you $1,001. And some judges would say, I'm kicking your case out because you've been offered everything you're entitled to. Now, sometimes we can legitimately claim emotional distress, and that can bump the value up. But in the grand scheme of things, these are not typically, real valuable cases. So we might have, I'm trying to think, this year we've settled, I don't know how many FDCPA cases for 6 figures. Okay. These are not 6-figure cases. These are like 5-figure cases, and or 4-figure cases. So, they may be 5,000 or 7,500, maybe 10,000. It also depends on how much do they fight you. Do they come in right away and settle, or are they settling after you've taken a deposition? So, but generally, these are, as we view FDCPA cases, these are sort of the lower rung of FDCPA cases. So let's see here. Debt collector filed a complaint with card member agreement for 2017 only. Alleged debt was in 2019. Oh, okay. So they sued you. The debt was in 2019, but they attach a 2017 cardholder agreement. That could be valid if it was never updated. In other words, if 2017 was the most recent card member agreement when the debt came into existence in 2019, then that would be appropriate. But if it's out of date, then that's something that you can raise. It's like, well, they don't have the actual sort of correct contract, if you will, for a credit card agreement. Let's see. And Stephen, I'm going to have to hop off here in just a minute. So let's see if we can plow through these. If an aged charge-off is settled, that item is updated, 0, that actually will hurt the FICO score. Yeah, a lot of times it will, at least temporarily. What I've seen, and I don't, claim to be a FICO expert, but I've seen sort of a quick drop, but then eventually, you come out better. And you have to balance that with underwriting. You may be trying to get a mortgage loan, and they say, well, I don't care what your FICO score is. You're never getting a loan with that outstanding charged off account. I get this a lot with law school graduates that are trying to sit for the bar, and their credit reports are pulled and they have charge off accounts. You can't sit for the bar with charged off accounts or collection accounts. Same thing with security clearances. So we have to just know what's our situation. It's like saying, well, what's better, sports car or a big, heavy duty pickup truck? Well, I don't know. Are we hauling stuff or are we trying to drive fast? So FICO score can definitely be affected. But sometimes we have to live with that because we need the other stuff. Let's see. Debt collector filed complaint, conflicting info about payments. Debt collector had last payment of 100. Statement of original creditor says no payments. So if this is a lawsuit, I would say, that can be helpful to show that, this calls into question the accuracy of the debt collector's information, and they can't even get the payments right. So I think that can be helpful to you. Any thoughts about that, Stephen?
Well, I think with Regulation F now, aren't they supposed to send you like 36 months of statements or something like that?
Yeah, there's what's called a model validation notice where they're supposed to tell you what this debt is about, and there's some differing views on what they have to provide or what these numbers are actually supposed to represent. But we're supposed to be getting more information now, and we'll see how that works out. Let's see. Debt collector called me, didn't identify herself as a debt collector, but did the day she was from Capio, hung up when I repeated her name. So
it sounds like somebody called you but didn't identify themselves as a debt collector, and you called them out and they hung up on you. Well, if a debt collector calls you and hangs up on you, wouldn't that be like an abusive practice right there, John?
It can be. I mean, there's literally something in the FDCPA about causing the telephone to ring repeatedly or in a harassing way. It's 1692D. But keep in mind, a debt collector does have to make sure they're talking to the right person. So they're not supposed to say, hey, this is John Watts, debt collector. Are you Stephen Palmieri? It's supposed to be, hey, can I
Who's
speak
asking? It depends.
Yeah. Are you giving me money or wanting money? Then I'll answer. Let's see. We have Peanut Man dispute portfolio recovery CFPB. Once they got the dispute, they added my current address from the dispute. They had another address from the. Okay, yeah, and I think that's just maybe going back to our question about how do they get, our updated address as well. The furnishers are constantly pushing information to the bureaus, and the bureaus are taking all this in and trying to, at least theoretically, trying to get the most accurate information. Whether they do a good job of that is up for debate.
That's where that whole interpretation of reasonable procedures comes in, right, John?
That's right. Let's see, it's removed from credit report. I think this is our one where we had the debt collector suit, I think. Let's see, furnishers never give me any proof I owe this other than asking me my name. So, if it's a collector that's continuing to contact you, and again, if you've identified yourself and then you've asked them for information, they never give you information, you may have something. I would just get with the lawyer in your state that does this type of work, and let's see. All right, our friend Timothy Williams here. Can a collection agency commit mail fraud for sending you an invoice for payment with no standing to contact with you? So it wouldn't be mail fraud unless, it literally was like fraud. A collector can send you a collection notice if you truly owe that debt or they believe you owe that debt. So my point is, if we have, let's say, Midland Credit says we're just going to mail out to everybody with the last name of Palmieri and say they owe us $10,000. Yeah, they got a lot of problems. Okay. But if it's they think you owe this debt, they send you a collection letter. It may be a violation of the FDCPA, but I don't think it would be mail fraud. So,
John, is it true that FedEx is outside the scope of the mail fraud laws?
I don't know.
I've heard that. The real smart criminals FedEx those fraudulent documents because that is not the USPS mail. So
that may be.
Yeah,
the only thing I know about mail fraud is I had some defense lawyers that sued a debt collector. They threatened me with suing me under RICO, RICO, for mail fraud.
You look like a racketeering, type of a guy. Just look at you, man.
You'll appreciate the humor of this. They said, I'm like, well, how did I violate RICO? They said, because we've tracked all your lawsuits and you sue mortgage companies and debt collectors and credit bureaus, and they pay you money and then you drop the case.
That sounds like racketeering, classic racketeering, like Al Capone.
Well, listen to this. You would appreciate this, dude. So then I put an article on my website. I said, are John Watts and Stan Herring mafia lawyers? And I went through this story. So we sued like a bank and a repo company. And when you do repos, it's like the guy that literally pulls your car. And then there's like a state repo that contracted. Then there's a regional repo. And then there's like the national repo. Well, the national repo, we said, all right, we want to take your what's called corporate representative's deposition. And the lawyer said, my lady is terrified to come to Alabama because she saw that you claim to be mafia lawyers and she's afraid y'all are going to murder her. I'm like, really? And did she read the article? Is she literate? Is she capable of understanding English words? And he's like, I'm going to go to the judge about this because, she's terrified. I'm like, please, let's go to the judge. And, anyway, so that's my only knowledge of mail fraud and RICO is apparently I'm a mafia lawyer. Let's see here. So we got Wanda. Thanks for the info. You're very welcome. Collector offered me a settlement versus paying the increased amount from the so-called judgment, forming that the original creditor had initiated garnishment. Well, I would just find out, do they have a judgment? And what is that with interest, and then decide what you want to do. So here's an interesting one that nearly covers our faces, which probably improves the video here, Stephen. I'll let you take this. Is there an effective way to dispute my way out of check system? So first of all, what's check system, Stephen?
That is a specialty consumer reporting agency. They have information on basically your bank accounts. If you have have closed bank accounts where you owe them money, too many overdrafts, things like that. So if you go to open up a bank, check systems is one of the bureau reports that they may pull on you.
So the account came back as verified. Evidently, we disputed an account. They sent some statements, an alleged signature card. I was thinking of disputing the validity of the e-signature, some type of UDAP. So I'll say this. It varies by court, but most courts rule that there are no state law claims against credit bureaus, and check systems would be a credit bureau. So you wouldn't be able to do a UDAP, depending on how your federal judges interpret that. My question would be, is it your account? I mean, is it your signature card? What this says is an alleged signature card. Well, I mean, if you had the account or not. And if it's not your account, then you really don't have to worry about like e-signature. You just make sure you dispute it and point out this is not mine. If it's not yours, it may be identity theft. Do an identity theft affidavit, get a police report. And if they don't fix it, then sue them. Now, if it is yours, what I would say is, sometimes we get people coming to us saying, well, yeah, that was my account, but can they really prove that was my signature? And I'm like, understand that most federal judges are going to be very practical. Like you say, well, that Capital One shouldn't be on my credit report. The judge is going to say, Stephen, did you have a Capital One card? Well, Your Honor, they can't prove I had a card. Stephen, listen to me. Did you have a Capital One card?
Well, see, Your Honor, technically speaking, no. My card was with Capital One, N period, A period, and the credit report just shows Capone.
And this is where the judge says, case dismissed,
So, but I want to touch base real quick on Jason's post, that last post we had there. So, because he's saying he may want to dispute the validity of the e-signature, right? So assuming, because we hear this all the time, people are like, well, can they prove the signature or whatever? So to your point, John, I mean, if it's really your contract, right, the main elements of a contract are offer, acceptance, and consideration, right, John? So, I mean, splitting hairs over like, well, do they have an IP address to validate or whatever? I mean, like oral contracts, they can say, oh, well, oral contracts, they have different statutes of limitations based on the states. But if you say you're going to do something, was that an oral contract? There's no signature at all. So I think it's important just to keep in mind that all you need is offer, acceptance, and consideration. So an actual signature itself, may not really be required per se. Is that a fair statement, John?
Yeah, there are lots of contracts with no signature. And but again, and I know this may not have been what he was talking about, but I was just using this as an example. To have an FCRA claim, there has to be an inaccuracy. So we can do the greatest dispute. The credit bureau can write you back and say, we would never consider a dispute from you, Stephen, because we don't like guys in Texas. Can you sue them for that? Well, the judge is going to say, where was the inaccuracy? Well, but they were really mean to me. Now they want to get to the heart of the matter. Was that your account? And then if it was your account, are they reporting it accurately as far as like opening the checking account, closing the checking account, being overdrafted? I'll say this, the specialty bureaus tend to be, if I can say it this way, they make the big guys look very sophisticated and accurate. As much as we talk about Equifax, Experian, TransUnion, Innovis, SageStream, those guys getting stuff wrong, and they do, these specialty places have like horrible standards. So I suspect if you sort of dig in it, you'll find lots of errors with check systems. Let's see here. I'm going to have to talk faster here. Crown is suing me, claimed to own the debt. Another company threatened to sue me for the debt. Well, if it's an illegal threat, in other words, if while Crown says they owned it, some other company said they owned it, you typically have 1 year to sue under statute of limitation for the Fair Debt Collection Practices Act. I would get with a lawyer in your state that does this type of work and sort of lay all this out, because that may be a good defense for why Crown doesn't really own it, because this other company did. We've had people sued by two companies at the same time. It's a great defense. They both claim to own it. Okay. So, definitely take advantage of that. And let's see, Wanda says, what's the difference between FICO and Vantage? So who created Vantage, Stephen?
That's created by the bureaus, because they wanted to be able to offer credit scores to consumers and not paying FICO the FICO royalty. So Vantage is created by the bureaus, and FICO is owned by FICO. Fair Isaac Company, I think, is what it used to be called, but I think now they just call themselves FICO.
Right.
Is there a way to get the creditor to use one or the other? I mean, no, they're going to use whatever they're going to want to use, and typically they all use versions of FICO. I don't really know of any lenders that use Vantage. Do you, John?
I mean, FICO, it seemed like when we were at CreditCon, didn't we have somebody from FICO there, and they said like 90% of lending decisions are made by FICO. I mean, I think Vantage has never really taken off. Again, it may be sort of directionally accurate. So like if you're trying to lose weight and you're using a scale that's off by 5 pounds, if you see the number going up, that's probably a bad sign. If you see it going down, that's a good sign, even if it's not technically accurate. So Vantage may not be what your mortgage broker uses, but it may give you an idea. Are you improving or going the wrong direction?
By the way, John, I have to ask, I hate to be that guy, but I'm that guy. When you're when you're in the courtroom and you use like air quotes or things like that, how does the stenographer record that into the permanent record?
She just takes a selfie of doing that. So
that's important for them to be able to record, the inflections and
that's right,
all the other nonverbal ways that you're communicating.
Apparently so. So we have Timothy. Here's a law states it's fraud if there is no contact for collection with consumer.
So
that would be a
contract. Yeah, he had another post where he changed contact to contract.
Okay. If no contract for collection with consumer. Yeah, I'm not familiar with that, and we can certainly take a look at that. But let's see, can or should you bring up how papers were served with no envelope, loose, gave complaint to a roommate? That really depends on what your state law allows. That may be entirely appropriate to hand those papers to a roommate. There's really no rule, at least where I practice, that it has to be in an envelope. I mean, they can serve you on an airplane and be like, hey, Steven. You're like, yeah. And like, you've been served. It's kind of awkward if they're sitting next to you, the process server, but
I think the distinction is, if it's serving a suit, then the FDCPA really doesn't apply, right, John? Because I think maybe what TP is saying is like for debt collection letters, they're not supposed to be loose and,
right.
But if you're being actually served, that is outside the FDCPA. Is that right, John?
Except like if you're sued in the wrong county, that can be an FDCPA violation if you don't owe the debt. So a lawsuit can be and often is an FDCPA violation, but the details of how that is handled is more of state law.
Awesome.
Let's see. Why doesn't Metro 2 have rules for Chapter 11?
I think they do. I'll have to go pull up the manual. But I believe they do have Chapter 11.
Yeah, and Chapter 11 is more commonly, as I understand, I don't do bankruptcy, but that's more of businesses as opposed to consumers.
Yeah, you can have personal Chapter 11s,
okay,
but they are most common for businesses. But yeah, I'll have to double check. EW, feel free to shoot me a message. I can pull up the manual and confirm for you with that.
So Timothy says, can a third party verify debt? That's an interesting question. I'm not sure I entirely understand that. Can a third party verify debt? What Timothy may be asking is like, you get a letter from a collector, you say, hey, send me proof, and they have the original creditor reach out to you. And in general, I think that's okay. Timothy may be talking about something else there. Um, let's see. Bria, case dismissed with prejudice, but I disputed the account, came back verified. How does that work? Well, if you got sued in, let's say, a collection case and it was dismissed with prejudice, we do have to look at your state law, but most state law, maybe every state law, says a dismissal with prejudice is what's called, and here's where there'd be a selfie, it's even a adjudication on the merits, okay? Which just means you won the case, okay? And so what I do is in Alabama, and when I get lawyers from other states that say, hey, this happened to my client, we dispute those. And we say, here's the lawsuit, here's the order dismissing with prejudice, get it off my credit report. And normally they do. When they don't, we sue them. So I would definitely, get with somebody about that, Bria. Let's see. Midland case dismissed with prejudice. Yeah. So, I think I have filed probably somewhere 40 to 50 cases against Midland for this exact thing. So that would be very unusual that it would be dismissed with prejudice and it comes back verified. You do have to make sure it's the same account. You get sued for $1,000 dismissed with prejudice, and there's another $1,000 Midland account, and that gets verified. So you have to match it up. Look at the original creditor, look at the account number, and if you have any problems, just get with me, Bria, and I'll be glad to walk you through it.
By the way, John, when you go to the courtroom, necktie or open collar? What's your style, my friend?
Oh, well, we have to wear a tie in court.
Yeah. All right. So you can't have like your chest hairs and stuff hanging out like you do right now. You gotta button it up a little bit.
Yeah, I hate wearing ties. Like I come out of the courthouse if there's nobody around, like
you're popping it loose, huh? I hear you, man.
Let's see. Disputed old charge off debt, original creditor, thought was fraud or identity theft. Later I found out it's mine. How do I pay the? Well, I would let them know that, you made a mistake with that. And because you don't want somebody to come back and say that you lied or anything. And this is part of the challenge, Stephen, is we get things and the name changes. Like I know looking at the 3 credit reports, the same account, it'll be like Synchrony Bank Kohl's. Well, another bureau will put it Kohl's. Another will put it like Capital One Kohl's. So like it hadn't been Capital One for however many years or vice versa, So it can be confusing. So I would just let them know and then reach out to them and talk about settling that. Let's see here. So the same thing. Will Midland refile now? If it was dismissed with prejudice, in every state I know of, they cannot refile. So you want to make sure it was with prejudice, not without. If it's without prejudice, they can refile. Let's see. We'll have the last 2 here. Why does Metro 2 use withdrawn when courts use closed and discharged, which are 2 different things? So I assume EW is talking about bankruptcy. So
you can have so you can have dismissed, you can have discharged, and then, so I know what he's talking about. There is some language about withdrawn. John, are you aware of much of the bankruptcy code? Is there a difference between a dismissed and a withdrawn? Like, can you file, and then like, let's say you filed it in error, can you have that filing withdrawn? Is that a thing?
I know that's happened. I thought it was just called dismissal. I'm not really that familiar with it.
Yeah. EW, I like your style, by the way, because, I love Metro too. That's kind of my game right there. And so definitely shoot me a message, man. And let's chat up on that. We can nerd out on Metro 2 together.
Yeah. Stephen can go super deep on that. So,
look, EW is asking me all the stumping questions. He's stumping me on that, man. So, you get the prize for that today, EW.
Let's see. My post chapter 11 was not about plans. Yeah, just get with Stephen on that, and I think he can help you. Bria says, thank you. You're very welcome. Counterclaims are what exactly? Can you give an example, plain English? So I assume we're talking about in the context of like a debt collector sues you, and then you hear people talk about file a counterclaim. That counterclaim typically would be under the FDCPA, Fair Debt Collection Practices Act, maybe a state law version, could be other state law claims like invasion of privacy. But a counterclaim this is not exactly true. It's true enough. There's no difference between a claim and a counterclaim. It's just, are you the plaintiff or the defendant? Okay. And I've been in cases where the plaintiff, let's say a corporation, sues me, and I counterclaim, and then they say, well, really, we ought to realign the parties, and we ought to make John's client the plaintiff, and we'll be the defendant. And so my point is, it doesn't really matter who files first, just in the abstract. Now, it can matter on, does something get removed to federal court? But a counterclaim is just a claim filed by a defendant. And you're saying the plaintiff who's suing me has done something wrong in the lawsuit or outside the lawsuit, but it's somehow connected. So Midland sues me for $5,000, but they told my neighbors that I owe this debt. Now, that doesn't make the lawsuit improper, but it means I can counterclaim against them and say, well, I may owe you money, but you owe me a lot more money. Okay. So hopefully that gives you a little bit of help.
So, I mean, it's very simple terms. It's kind of the equivalent of if you were to sue them back, but you're not really suing them back because there's already an active lawsuit.
But not a different lawsuit. It would all be in that
right.
original
But it's conceptually, they sue you, and then conceptually, if you were to sue them back, but it's all in the same lawsuit. That's what a counterclaim is.
Yeah, and there are rules about, can we do it separately, or does it have to be all in that one lawsuit? And let's see, paid off medical bill, went to collections, paid the doctor directly. It still shows on my credit report. I would say, first of all, does it show a zero balance? Does it show paid? And did you pay the doctor before it was reported? And when it was reported, was it reported with a balance, not a balance? This is not really a legal thing, but a lot of times if you go to the doctor and say, hey, I paid you, and this collector's trashing my credit report, they'll tell the collector to get off of your report. And that solves it a good number of times. So here you go. How to contact Steve.
Stephen at StephenPalmieri.com. So it's Stephen with a V. And then my last name is Palm, as in Michael, I-E. There you go, right there, M-I-E-R-I. Stephen at StephenPalmieri.com. Or you can go to StephenPalmieri.com. I'm also on Facebook, YouTube, and everywhere in between.
And let's see, do you know an attorney in Texas? So
yeah, we've got some. Yeah, we can refer you, right? I mean, I'm sure you have some. I know we both know some mutual people.
Yeah, I'm trying to think if there's anybody in our.
Well, Chris, Chris is teamed up with
Chris Ebert.
John's just down the street from me.
Yeah, that would be somebody. So if you just reach out to Stephen or to me, and we can connect you with Chris Ebert. He works with the lawyer. Chris is a super knowledgeable guy. And let's see, Bria says zero balance, paid after I went to collections. Yeah. So if you paid after you went to collections, arguably it's okay for that to be on there, but I would still go to the doctor, and I would look at how the collections reporting look on. Stephen likes to make fun of me. Look on your real reports through annualcreditreport.com.
You didn't say it in air quotes this time, so I know you're not serious.
Real reports. And you'll often find errors with those collectors. And so I go to the doctor, go to your real reports, and see what you find there. All right, guys. Well, I've got to wrap this up, and we got to let Stephen get back to saving the world from the great state of Texas. And maybe we'll see you guys shortly before Christmas, or definitely in the new year. And everybody have a safe rest of the day, the week, and the year. So
take care, everybody. Thank you guys for watching.